Good afternoon, ladies and gentlemen. My name is Todd Cook, and welcome to another one of the Beresford Booth lunchtime webinars. Today, I am going to be talking about some comparisons between forms of ADR and the most two common forms, arbitration and mediation. And before we get into what those forms of arbitration are, I wanted to explain who I am so it makes sense why I'm talking about this. I am a member of Beresford Booth's litigation team. I've been at the firm since 2018. I graduated from law school and passed the bar in 2002 and started out my career as a lawyer as a federal judicial law clerk. That meant I worked directly for a federal trial court judge, helping the judge decide motions and other decisions brought or other requests brought to the court. And for the last 18 years, I have been working in private practice as a civil litigation attorney. And the key there is civil. I do not practice criminal law. So today, I'd like to talk about ADR from a civil law perspective. And there are ADR mechanisms in the criminal context, but that is beyond the scope of today. So I've used the term ADR several times now. You may be asking yourself, what does ADR stand for? And it stands for Alternative Dispute Resolution. And that begs the question, what is an alternative to? And it is an alternative to traditional civil litigation. So before we get into the forms of ADR, I just want to set a baseline of understanding regarding civil litigation. So civil litigation is when two parties have a dispute and one of them takes it to the public court system by filing a complaint either in state or federal court. In that case, there will be a lawsuit that is assigned to a judge, either a federal judge or a state judge. It will then be governed by either the state or federal rules of civil procedure, which establish all the rules for discovery practices and pretrial procedures and trial procedures for the case. A civil litigation matter can be a very extended event. It's not uncommon for complex cases to sit on the court's docket for years, even up to 5 years or more sometimes. So it can be more streamlined in certain courts, such as the King County Superior Court, where the court puts in a scheduling order that sets a trial date at the beginning. But in a lot of courts, including, for example, Snohomish County, there is no schedule and the case proceeds until someone takes it to trial, and that can be a long time. So there are a lot of lawsuits in the federal and state court systems, which causes congestion and leads to delay. And that's certainly been heightened since the COVID-19 pandemic started in 2020. And so courts are always looking to litigants to try to engage when they can in forms of alternative dispute resolution to relieve the burden on the public court systems. So the two most common forms of ADR are mediation and arbitration, and that's what I want to talk a little bit about today. These aren't very complex issues, so I'm going to try to streamline this and get us out of here early. Now, from a fundamental standpoint, from a base understanding, all these are completely different alternatives. They are fundamentally different things. Arbitration is much more like a civil litigation. It is a process that leads to a third party other than the plaintiff and defendant making a decision. And a mediation is a form of negotiated settlement process. So I'd like to start with arbitration because arbitration is closer to civil litigation. I've just realized I have not been sharing my screen properly. So let me catch up here. Okay, so arbitration can look a lot like litigation in a state or federal court. It is essentially a substitute for litigation in the public court system. The main difference is that it's not in the court. So there's not a government employee with the title of judge who presides over the proceeding. Instead, there is an arbitrator, sometimes one arbitrator, and sometimes a panel of 3 arbitrators who will be the decision maker in the case. So the parties, just like in a civil litigation, have brought a claim. In court, they call it filing a complaint. In arbitration, it is filing an arbitration demand. And rather than a judge being appointed as the decision maker, one or more arbitrators will be appointed as the decision maker who will decide the dispute for the participants. Now, the decision maker is typically a experienced, seasoned lawyer who has been doing it for a long time and really focuses their practice in providing mediation or arbitration services. And many arbitrators will be former judges. Many judges, after they step down from the bench, continue their career by going back into private practice and using their skills that they've learned on the bench to help decide cases in a private setting through arbitration and mediation. So typically, any case can be taken to the public court system so long as it meets jurisdictional standards, which are broad for the trial courts. Not every case can go to arbitration. Typically, a case only goes to arbitration if the parties have agreed to it. So you see this oftentimes, or most times, in a dispute that is governed by some contract between the parties, where the contract agrees in a dispute resolution clause that the parties will decide their disputes by arbitration. And those agreements can spell out the terms of how the arbitration will look, where it will take place, timelines, how the arbitrators will be appointed, and whatever else the parties want to agree to. So once the arbitration is agreed to and commenced, it looks fairly similar to a public litigation case in the state or federal court systems. But instead of happening in the courthouse, it will happen in a conference room, typically of the arbitrator. Another major difference between civil litigation in court and in arbitration is that civil litigation in the court is governed by the Washington civil rules for the Superior Court, or the federal rules of civil procedure, and the federal rules of evidence, and in state court, the state rules of evidence. In an arbitration, the proceedings and the procedures and the discovery will be governed by the rules set either by the parties or by the arbitrator. Typically, this is done by the parties agreeing, for example, that the dispute will be governed by the AAA rules. AAA is the American Arbitration Association. It has a robust set of rules that dictate how arbitrations in their system are handled. Generally, the procedures in an arbitration and the rules of discovery will be more streamlined. The idea is that it will be it will be a more efficient process. It will happen more quickly, get the case to resolution sooner, and hopefully with less cost to the clients, to the parties involved. With that understanding, I'd like to talk about some of the pros and cons of arbitration. One of the first pros is that it's private. Cases in the public court system are subject to right to know laws, and they're public events. So there's a public docket. People can see what's being filed. People can see resolutions. And so if your matter is decided through arbitration, it can be much more easily kept confidential. The private nature also reduces congestion in the court system because your case is being handled privately and not through any action in the court. As discussed, the rules are usually streamlined and they yield a quicker resolution. I've seen many arbitration provisions that dictate in the agreement that the parties will arbitrate and the arbitrator will be appointed and render a decision on the merits within a set time period. I've seen as few as 90 days. So, a typical case will last at least a year if it's going through trial in the court system, oftentimes a lot longer than that. I have personally had a very large, complex, high dollar value case that went through a private arbitration with a panel of arbitrators where the entire dispute was resolved within, I believe, about 6 months. The next pro is that it is less expensive. Now, I say here that this pro is often illusory. There are aspects that lead to the possibility of an arbitration being less expensive, but there are other things that counterbalance that or sometimes overweigh that. The main thing about cost savings is that it's less expensive. So there will be less discovery in the federal and state courts. Discovery, the process of seeking documents, taking depositions, can be very broad and take a lot of time and be really the most expensive part of the entire case. In an arbitration, the arbitration rules typically limit the discovery well beyond or well below what is typical in a public court litigation, and the timeline of the case will just be shorter, and that leads to less time to incur attorney's fees and hopefully lower cost. Another pro is that it is more flexible from a scheduling perspective, and I say that really more broadly than just scheduling on timing aspects. There's just much more flexibility with a arbitration. First off, you're dealing with an arbitrator who is there because the parties agreed to work with that arbitrator, as opposed to in a court system where you are just another case assigned to a judge. The judge sets the timelines and makes all the rules, and you really have to conform to what the judge, how the judge is going to handle your proceeding. In arbitration, it is much more typical that schedules will be set by agreement between the parties and the arbitrator, but not just it's not just, as I said, timing that's more flexible. Location can be more flexible. In a court case, it's a little different today because there's a lot of remote Zoom-based hearings happening since the pandemic started in 2020. But typically in a traditional civil litigation, when you get to trial or when you get to any hearing in front of the judge, it's going to be downtown in the courthouse, and that is the only option. In a arbitration, the parties can agree where it happens. You could have parties in different states, and they could agree to have the arbitration proceedings and hearing take place in either of those states or a neutral third location that's more convenient to both of them. There's just a lot more flexibility than when you're in a court proceeding. There are cons, however, with an arbitration. And the first con is one of those ones that counterbalances the pro of it being less expensive. And that is that the decision maker is being paid for by the parties. So the decision maker in a court proceeding is a judge who is an employee of the federal or state government and is being paid by the government to decide cases brought to the court. In an arbitration, the parties typically split the cost of the arbitrator's fees. The arbitrator is usually has fees that are on par with a partner at a large law firm. So it can be a situation where you're essentially, as a party, paying your own attorney's fees and half of the arbitrator's fees. So it can be like having another attorney involved that you have to pay for. It increases even more when there's an agreement to have an arbitration panel. You may be paying half of the fees for up to 3 arbitrators. I think that a panel of arbitrators is probably less common than a single arbitrator, but I think that when it happens, it's usually because the parties can't come to an agreement or don't think they'll be able to come to an agreement on a single arbitrator. So typically they'll have a format where one party will pick an arbitrator of their choice, the other will pick an arbitrator of that party's choice, and then those 2 arbitrators will pick a third neutral arbitrator. And all those arbitrators cost money throughout the process. Whenever they're making a decision, holding a hearing, you are paying an hourly fee for their time. The next con for an arbitration, which to me is the biggest con for arbitrations, is that it is much less predictable than a case in court. And that's largely because the rules are applied differently. In state or federal court, there are clear, long-standing traditional rules of evidence that govern what evidence comes in and what evidence doesn't come in at the trial. And those rules may be applied somewhat at an arbitration, but they may not be applied at all, and they may be applied only loosely. Therefore, your arbitrator may make a decision based on evidence and testimony that never would have come in a traditional court setting. And the arbitrator, the final con really adds, plays into the less predictable factor. It is essentially a final decision that will be basically unappealable. That means essentially because the parties have agreed that they are going to have a private decision maker, the courts will hold them to that and say, well, you wanted a private decision maker, and you agreed to this private decision maker, so we're going to defer to that private decision maker. That can add less predictability and less supportable outcomes sometimes, because the arbitrator isn't going to be subject to reversal on appeal typically, as a trial court would. For example, if a trial court makes evidentiary decisions that are incorrect and impact the outcome of the trial, the losing party can appeal and potentially get a new trial if the appellate court finds that it was prejudicial error to let in the evidence. But that is basically the arbitration process. It is a substitute, private substitute for the litigation process. It looks a lot like the litigation process, and the key is there's a decision maker. So whenever there's a decision maker, like a judge or a jury or an arbitrator, the ultimate decision and resolution of the case is completely out of the party's hands. They're going to put forward their best case through their evidence, but the decision maker is going to decide the outcome. And that is a major distinction between the next form of ADR that I like to discuss, and that's mediation. Mediation is fundamentally different because there is no decision maker. It is not a litigation process. I mean, it is an event that can happen within a litigation, but it is fundamentally different from the process of filing a complaint and going through discovery and having a trial where a decision maker makes a decision. At mediation, there is usually a one-day, although it can be longer than that, meeting that we call the mediation, where a neutral third party will assist the parties in trying to reach a amicable resolution of their claims. So the neutral third party is often someone very similar to the arbitrator. It is a seasoned lawyer who specializes in mediations, or oftentimes it is a retired judge. An interesting thing about a retired judge is that they have experience on the bench deciding cases, and oftentimes presiding over cases that are often similar in nature to the cases that they are mediating, so they can use that experience to help the parties understand how the jury may view the case. And the process of mediation is essentially a meeting in a conference, in a building with conference space, where the plaintiffs or one party will be in one conference room, the other parties will be in another conference room, and the neutral will shuttle between the two and engage in shuttle diplomacy, where they talk to one party and try to get the sense of their claims and their demands in the settlement, go to the other party and do the same, and then really try to work with the parties to come together by educating them on how a neutral observer is viewing their claims and the risks and relative strengths of the two parties' claims. The major distinction that I already mentioned with a mediation between a mediation and arbitration is no resolution is guaranteed. That can be both good and bad, as I'll talk about. You can go to mediation. If you go to trial, there will be a decision. The decision maker will decide the dispute. If you go to mediation, it may fail and there may be no resolution. There will only be resolution if the parties come together and agree. So again, like with arbitration, there's pros and cons. The first pro, in my opinion, of mediation is that it's relatively inexpensive. It is not a full litigation process. It's a discrete event, so it usually involves the parties' counsel preparing mediation statements, which can look similar to briefs filed in a case, but they're typically a little less formal. They're designed to give the mediator the relevant information that they'll need to do their job at the mediation. It may provide exhibits that support the party's position. And after the submission of those, it's typically a one-day event where again, like in arbitration, the parties are paying for the mediator's fees, but instead of a long, months-long process, it is typically a one-day process. Another pro is that in the mediation context, it's a negotiation. It's not a adversarial process where a decision maker makes a decision. It is a negotiation, a cooperative process where the parties are both amicably trying to work towards an agreed settlement. So the third party there isn't there to make a decision, but to evaluate the cases and potential risks and help you make the best decision and reach the best outcome of your case. Now, they're not necessarily looking out for your best interest, but what I'm saying is they're trying to make sure that you are aware of the risks that you face, including, risks of not winning your case, with risks of winning your case and having the other side be judgment proof, risks of that it will, just cost a lot to proceed through trial. All of those factors, the neutral will help both sides try to get an understanding of the relative merits of the case and what they what risks they face if they go forward to trial. So that is a good process, because in the litigation process, the client usually only talks to their own attorney, who is on their side and is trying to develop the best case for their client. So it is helpful for the third party to get, for the client to get the third party's view. Someone who has no duties or allegiance to the parties will come in and help you see how a third party would see the case, and that is a corollary for how the jury or the judge may see the case. As I said earlier, the parties just have much more control over the final resolution, because resolution only happens by agreement. The parties can craft whatever agreement they can mutually agree upon. This is a good thing, because when you go to trial and the court, the judge or the jury is going to make a decision, it is oftentimes a win or lose situation. One party's going to win and the other party's going to lose, and no in between. So you have all the risk and all the reward of going through with the trial. You may spend all the time and effort and expense to get to trial and come away with nothing because the jury disagrees with your evidence. So in a mediation, the parties can compromise and come to a decision, a resolution that never would have been one of the potential outcomes at trial, somewhere in between, where everyone wins a bit, everyone loses a bit. I've heard mediators say to me before that if the mediator is doing their job right, everyone should be a little bit mad at the mediator by the end of the day, because they're saying things that they don't like, that the client doesn't like about their case, and making them face some realizations about potential risks, and ultimately coming up to a conclusion that isn't necessarily their ideal resolution, but it's one that they can live with. It's a compromise that both parties decide is better than facing the risk of going to trial and not getting the outcome they want. Now, another pro of mediation is that it can happen at any time. It can happen before there's a lawsuit. There may never be a lawsuit, and there could be a mediation. There may be a lawsuit in the public court system, in the Superior Court in Washington State, or in the federal court. And during the course of that, the many months leading up to trial, the parties can agree to engage in a mediation. Same thing if there's a private arbitration going on. At any point, they could agree to mediate. And even after trial, some appellate courts even have a requirement that before you go to the final argument before the appellate panel, that you take a shot at mediating the dispute to see if you can come to resolution even after trial. So it's very flexible, and if it doesn't, if it isn't successful, you can go right back to the process that you're already involved in the court system or in the arbitration system. And there are some cons to mediation as well, although I don't think that there's all that many, because it is a less expensive process. So the main cons in my mind about mediation is that It is an expense. There is some expense involved. And it, for example, it is, you know, a greater cost because you're employing a mediator to provide the perspective and services of a neutral third party. And you wouldn't incur those costs if you were just having party-to-party negotiations. But it's relatively quick and inexpensive. So I think those are all actually good things, but there is no resolution guarantee. So you're you know, taking on those added expenses to have sort of a heightened form of settlement negotiation, and there is no guarantee that any resolution will come out of those additional expenses for the mediation. Again, I think that it's often, you know, I'm saying the lack of guarantee is a con, but I think that it is often worth the shot to take it, to take a case to mediation because of the control that you can get if the parties are willing to settle. Now, because there's no resolution guaranteed, the main thing is you really need parties who want to settle. If the parties come into mediation and they're entrenched in their positions, or they're just not ready for whatever reason to settle and compromise, the mediation could prove to be a waste of time. And this has certainly happened. Sometimes parties, you know, go through the process, hire a mediator, submit mediation statements, and at the mediation, they're just not willing to make, you know, real movement towards settlement. If you're going to settle a case, you know, at mediation, the parties really do need to be ready to compromise. But that is essentially the mediation process. So mediation and arbitration are both processes of taking decision making or resolution of disputes out of the public court system. I think that mediation happens much more frequently than arbitration, but they're both available mechanisms for people with disputes to consider instead of going through the traditional court system. If you have any questions about mediation, you can, or arbitration, you can certainly feel free to reach out to me. My contact information is on the screen, and I would love to discuss any matters with you. But that is it for my presentation today. I thank you for joining me, and please check in with us next week where my colleagues Per Oscarson and Linda Nash will be presenting on a topic within their group of estate planning and probate. Thank you.